Here we go. Welcome everyone to our Landlord Lunch and Learn series presented by the Landlord Self-Help Center. This is our webinar number 3 of our spring series. My name is Diana Padierna, and today I'll be joined by Natalia Debsky and Ender Joseph, all licensed paralegals employed with the Landlord Self-Help Center. Please note that even though we're the Landlord Self-Help Center, we believe this information will be beneficial to both landlords and tenants. You can also visit our website at www.landlordsselfhelp.com, where you will find numerous resources such as fact sheets, FAQs, modules, presentations, etc. Our website also contains information on how to contact us by phone, email, and in person. We will start today's webinar by giving you a brief introduction on who we are at the Landlord Self-Help Center and what services we provide. We will then talk about what happens on the day of the hearing, what happens after the hearing, and what to do when you receive your order from the Landlord and Tenant Board. This will take about half an hour in total, and we will then have ample time for our Q&A period where you will have an opportunity to ask questions pertaining to this webinar. So the Landlord Self-Help Center is a nonprofit community legal clinic funded by Legal Aid Ontario that operates with the mandate to support the landlord community. According to our criteria, small landlords are those who live within the same property where the rental unit is located and offer up to 3 rental units in a basement, duplex, triplex, or fourplex. The center educates and informs small landlords across Ontario. We help them learn and understand their rights and responsibilities as housing providers. Approximately 80% of our resources are dedicated to providing frontline services. The majority of these services are in the form of summary legal advice and brief legal services. The Landlord Self-Help Center helps small landlords with a full range of issues related to renting, from providing information we call Before You Rent, which includes everything a new landlord should know prior to committing to a tenancy agreement, to the eviction process and collection process, and everything that you could imagine in between. In addition to advising walk-in clients, responding to email inquiries, and developing educational materials, we provide summary legal advice to over 70 clients over the phone each day. And typically, the center helps 12,000 clients per year. Due to our limited human resources, we do not assist with above guideline rent increase applications, mobile home or trailer park issues, care home issues, commercial tenancy matters, head tenants. We mainly provide summary legal advice, and we do not provide legal representation. The Landlord Self-Help Center's website is designed as a learning tool and serves as the first point of contact for many inquiries and research. The new website contains general information in various formats, such as videos, fact sheets, podcasts, etc., on a variety of residential tenancies, act topics, and problems commonly encountered by our landlord community. The Landlord Self-Help Center involves itself in lobbying for legislative and procedural reform, which will benefit the small landlord community in Ontario. Lobby efforts are completed in the form of letters, submissions, participation and consultation opportunities, or petitions. We often engage our client community through the use of an online survey to gather input and feedback on particular issues to assist in our law reform efforts. Lastly, we offer a membership program, which includes a subscription to the quarterly newsletter and access to the members area of the website, where rental tools, including additional terms to include in the standard form of lease drafted by the Government of Ontario, rental applications, inspection reports, and notices to enter can be downloaded. For more information on our membership program, please visit our website at www.landlordsselfhelp.com. Thank you for your attention. Okay, so I'll pass it over to Ender.
Yes, thanks once again for joining us today. Before we continue with the main part of the presentation, we would just like to ask you to take a couple of seconds just to answer our poll questions. We are presenting two today and we're just doing them back to back. So if you don't mind, again, I'll share the first poll with you, and after that, I'll share the second. Thank you.
Thank you so much, Ender. We will now learn about what happens on the day of the hearing, what happens after the hearing, and how to proceed once you receive your order. Please remember that we will answer your questions shared through the chat during our Q&A period at the end. Welcome to the Landlord Self-Help Center Lunch and Learn series. This is our third presentation entitled Hearing Date and the Order, What to Expect. In our previous presentation, we talked about what happens after you file your application with the Landlord and Tenant Board and how to prepare for the hearing. Today we will be discussing what happens on the hearing day and how to read and understand an order from the Landlord and Tenant Board. Up until this day, the Landlord and Tenant Board is still conducting virtual hearings through the online platform Zoom. Mainly, there are two hearing blocks which your hearing may be scheduled at, the 9 a.m. block and the 1 p.m. block. You will know which hearing block you will be participating in from your notice of hearing that was previously provided by the Landlord and Tenant Board. Your notice of hearing will also provide you with a Zoom meeting ID. As the hearing will take place through Zoom, ensure that you have a working Zoom account set up. If you are not familiar with this platform, familiarize yourself with it prior to the hearing to avoid unnecessary delay. The notice of hearing will also provide you with a phone number to call in into the hearing if you prefer to call in. It is recommended to log on 30 minutes before your hearing is set to start to ensure you have no technical difficulties. Once you log onto the hearing, you will be in the same hearing room as everyone else who has a hearing that day. There is a moderator who is responsible to sign all parties into the hearing and may ask for your full name and address of the rental property in question. The moderator will assign the parties into a breakout room where the adjudicator who is presiding over that hearing block is present. Parties can expect to be in the hearing room for the majority of the day or hearing block. For example, if your hearing starts at 9 a.m., you may be there until the start of the 1 p.m. hearing block. Your case may also be heard until the afternoon, so it is better to be available for the entire day. The duration of the hearing itself will vary depending on a few factors, such as type of the hearing, how much evidence was submitted, how many witnesses are there, etc. Typically, 45 minutes is allocated to one matter. If the matter has many witnesses and evidence, the adjudicator has the discretion to adjourn the matter if they believe they do not have sufficient time to complete the hearing in one day. Once the matter in question is called, an adjudicator will ask the parties to state their name and their relation to the matter. Adjudicators are familiar with the legislation, rules, and procedures. They must be neutral and impartial when making any decision. The structure of the hearing will depend on the adjudicator, as each adjudicator may have a different way of conducting their hearings. For example, some adjudicators may start by asking if there are any preliminary matters. This may give the parties an opportunity to state any issues that they would like to discuss before the hearing starts. A preliminary matter may be when the opposing party points out an issue with a notice of eviction or the application. The applicant or the party that filed the application with the Landlord and Tenant Board is the first one to speak. They may start by providing an opening statement or going right into presenting their application and evidence. It is important to note that the adjudicator cannot give any legal advice to the parties during the hearing. The adjudicator has the right to ask both parties questions pertaining to an issue, or evidence during the hearing for clarification purposes. If you have evidence to present, you may do so during the time you are called to speak. If you have witnesses, you may call them to speak at the hearing when it is your turn to present your application. It is important to advise the adjudicator that you have witnesses to ensure they're not in the same room. Once the adjudicator allows you to call a witness, they will be readmitted into the hearing room. You may then proceed to ask the witness questions to assist in proving the allegations in your application. It is important to be mindful that when asking questions to the witnesses, they need to be relevant to the matter in question. The adjudicator is able to stop you if there is an irrelevant question such as a leading question. This type of question includes the answer you are looking for in the actual question. Once you are finished asking questions, the tenant will have an opportunity to cross-examine your witness on any information that the witness provided. You may present documentary evidence when presenting your matter. To present this type of evidence, you may ask the adjudicator and the tenant to turn to a specific page or document in your evidence. You will then be able to explain what the document is, how it is relevant to your matter, and how it supports an issue in your application. The adjudicator will have the opportunity to ask further questions about the document and clarify any potential issues, if any. It is important for the parties to ensure that their evidence is relevant to the matter, as the adjudicator or the tenant may oppose a piece of evidence or question being presented if it does not have anything to do with the issues in question. Once both the landlord and tenant present their evidence, the adjudicator will commence the process of making a final decision in the matter. After hearing all the merits of the case and listening to all the evidence presented, an adjudicator can reserve their decision, which means that the adjudicator will take some time to review all the evidence and issue a written order reflecting their decision. If the matter is not complex, the adjudicator may choose to verbally advise you at the end of the hearing as to what their decision is. This is more common with an application when there is no opposition to the claims being made at the hearing. It is important to note that even when an adjudicator issues a verbal order, nothing is set in stone. On occasion, a member, upon reviewing a file to make the official order, can make a ruling that is different than what was communicated verbally at the end of the hearing. It is important to have a written order before proceeding unless otherwise directed by the adjudicator. You will receive a copy of the order by email if your email was provided, or it will be sent by regular mail. There are several types of orders that can be generated as a result of a hearing. For example, you may get a payment plan or a probationary order where the adjudicator will lay out the terms in the order which the tenant must follow. This type of order usually contains the Section 78 clause, which gives a landlord the opportunity to file a subsequent L4 application for eviction with the board if the tenant does not keep up with the terms and conditions indicated in the order. The L4 application usually results in what's referred to an ex parte order, meaning an order generated without further hearing. An interim order may be issued when a hearing is adjourned. A party can request an interim order to ensure that the situation at hand will not escalate past the current position. In this type of order, the adjudicator will require a party to do or not do whatever is stipulated. Failure to comply with an interim order will have negative consequences for the contravening party. An order for arrears is the result of an L9 application where eviction is not included. The tenant is usually directed to pay the outstanding arrears by a certain date, and failure to do so will allow interest to accrue. If a tenant fails to pay, then the landlord has the option to file this order for garnishment. An eviction order is an order to evict a tenant based on the reasons presented by the landlord during the hearing. This type of order states a date by which the tenant must vacate the rental unit. The order will further state that if the tenant refuses to vacate on the date specified in the order, the landlord, on the following day, can take the order to the enforcement office, also known as the sheriff, to have the eviction enforced. An order will have the official Landlord and Tenant Board stamp, as shown here. On the very last page, the order will also indicate the adjudicator's name, signature, and date the order was issued. An order usually comes with multiple pages. Orders generated by the Landlord and Tenant Board usually follow the same format, starting with the names of parties and witnesses. Names of all parties will appear at the top of the first page of the order. However, only the parties and witnesses who appear at the hearing will be mentioned. Another heading is determinations. This section of the order shows the adjudicator's summary of evidence provided at the hearing. This will reflect the adjudicator's findings on the matter. The last heading reads as decision and says it is ordered that. This is where the adjudicator's decision can be found. This will tell you what the adjudicator has concluded based on the evidence provided. It will also highlight directions to both parties in order that they act accordingly. When in receipt of an order, it is important to note the following. What type of order is it? What actions can be taken after receiving the order? What are the timelines on the order, and be mindful of upcoming dates? And lastly, get familiar with how to correctly initiate and complete the steps listed on the order, such as filing for eviction with the sheriff. A mistake in the order may have serious consequences and can result in significant delays. Thank you for watching our third Landlord Lunch and Learn presentation. We look forward to assisting you.
Thank you very much for your time. And now we will proceed to answer your questions pertaining to this webinar, which we're sharing in the chat. Are you, Andrew and Natalia, ready for the Q&A?
Definitely, yes.
Yep. Okay. So some of the questions that we received, one of the questions reads as follows. When you apply for an eviction, how long does it normally take to get a response for a date? Natalia or Ender?
I can answer that one. So yes, so once you file your application, it depends on ultimately how busy the board is at the time. There is not a consistent that we know of or that the LTB has set with respect to a timeline of when you're going to be in receipt of a response. When you file your application, you will be advised that it was submitted within a few business days of filing the application. We have been seeing anywhere between 3 to 7 days at the clinic from the landlords that we speak with. And then to get a notice of hearing, it depends on the application you filed once again. We've been hearing as well that for an L1 application, which is for arrears of rent, some landlords are actually able to select the hearing date and to schedule the hearing 3 to 4 months from when they file it. But for some other applications, that is not the case, and the landlord will be in receipt of a notice of hearing within 4 to 6 months is the time right now.
Okay, thank you so much. That's actually more or less related to the next two questions. It's about timelines with the board and how long they're taking, processing applications. So I'll just go ahead and read the other two. Are the applications reviewed? If yes, do you, as the landlord, do you notify the landlord, the board? Does the board notify the landlord if there are any missing documents or any mistakes in the application? If you don't, and the second question is, if you don't notify the board, if the board doesn't notify the landlord, how long do you have to wait before you contact the board to find out why you haven't received a date?
So I can go ahead and take this one or these two. Firstly, the expectation from the landlord and tenant board is that the applications that you submit are vetted. We have seen situations where applications are filed and the board has reached out and advised the applicant that there's been an error, whether it's in the application itself or in the notice. Obviously, again, and we've touched on this prior in our prior Lunch and Learn series. If it's an error with the notice, you would be expected to withdraw and start over. If it's an error with your application, the board may give you an opportunity to correct, and they usually provide a list of errors that were found. Unfortunately, again, we do know that filing with the portal is fairly new, and it comes with kinks, and so there are some applications and notices that does slip through the cracks, and unfortunately an applicant may not find out about an error until they get to the board. So our advice to you would be to just again try to dot all your I's, cross all your T's before you actually submit an application to the board, and not just leave it to the board. If the board did not advise you of this error and you do catch that error before the hearing, again, on the application, you can ask the board to amend. Unfortunately, if not, then you go to the hearing and ask there and hope that the adjudicator will consider amending. If you are not given an opportunity to amend, then unfortunately you'll have to start the process all over again. Did I miss anything with that question, Diana?
No, but
Okay.
just if you want to go ahead and address the third one. So if the board doesn't notify a landlord, how long does the landlord have to wait before contacting the board to find out why the landlord hasn't received a date yet?
Okay, so that again speaks to the delay at the landlord and tenant board and how busy they are. Again, as Natalia briefly touched on, we've seen landlords get responses within 7 business days. Unfortunately, we've heard of cases that applicants are waiting 30 days or more. I would say 30 days, maybe a bit on the outskirts. So if you're waiting around the 30-day mark, we would advise you to contact the landlord and tenant board. If you filed in the portal, you can inquire via the portal, but we always advise that you email the landlord and tenant board at, I think we all know this email by heart by now. It's the ltb@ontario.ca email. Be sure to put your file number in the subject line if you don't have a file number as yet, because you have not gotten a response or confirmation from the board that they received your hearing, your application. Then when you're reaching out to the board via email, we use the subject, possibly maybe include even the address of on the application of the rental unit. But I would say 30 days would be the maximum that we would say wait to hear back, and then inquire for sure, because you never know, maybe something slipped through the crack again, and then you're waiting forever. So 8 months, I think someone mentioned, is a bit outside the ordinary right now, and definitely you should be following up at that point.
Thank you so much. I'm just going to share the email address. Like you said, everyone may know, may be aware of it, but just for those who are not aware of the landlord and tenant board contact email address, then I'm going to share it in the chat. So you said it's ltb@ontario.ca. Okay, so I'll send it right now so everyone can have it. Okay, so another question that we got says as follows. I tried to log into my hearing through Zoom, but it is not working. Can I call in? We kind of already talked about it during the presentation, but I don't know. Natalia, can you address that question, please?
Yes, absolutely. You can call in. So if you look at the notice of hearing that you were provided with from the board with all of the login information for the Zoom, there's also a phone number that you may call and you can call into your hearing. As we mentioned, we do encourage to make sure that you're able to potentially use Zoom. If you would like our advice on that, when you see somebody in person, you're able to see what's going on and who's speaking and the environment of what's happening, through the hearing. It would be advisable if you can log in through Zoom. But once again, if you can't and it's last minute and you would like to be present at your hearing, because that is ultimately the most important, you can absolutely call into the hearing using the number that's provided on the notice of hearing.
Thank you so much, Natalia. Another question that we received says as follows. Can I proceed based on a verbal order? Ender, would you like to answer that, please?
Yes, sure. And we did touch on this briefly in the presentation video a while ago. We've seen situations where an adjudicator, in reviewing all the evidence, may change their ruling. So, and again, you can't take a verbal order to the sheriff if that's the order. So you definitely should wait for a copy of the order. We did show a photo of the stamp, the official landlord and tenant board stamp. So you would need a document that reflects that in order to proceed with next steps.
Okay, I'll just read the next question because I think it's related to your answer. One client says, I received my order by email. Is it valid if I just print it at home?
I can take this one as well, seeing that it's a follow-up. Yes, because again, things have changed at the board. Prior to the pandemic, you would definitely have to wait for the official order through the mail. Most orders right now are being sent through email, and they do bear that official stamp or seal. So once you receive an order with that official stamp, it is valid and official, and then you can proceed accordingly.
Okay, thank you so much, Ender. Another landlord is asking, what do I have to provide my tenant with a copy of the order if I receive my order by email? Natalia, maybe you can answer that, please.
Yep. So the board will provide the order to the parties involved. So both the applicant and respondent, if in this case the landlord's the applicant, they'll ultimately be in receipt of it, as well as the tenant who would be the respondent in that matter. The way that they will provide it is if the tenant, you provided the tenant's email address, and if they've been in receipt of other communication from the board via email, they may expect the order to be sent via email. If it was by mail, it would be mailed to them. So the board will provide a copy of the order to the tenant.
Yeah, it is usually as well, the landlord and tenant board, if they want one of the parties to give it to the other party, they will say it in writing, right? Okay, so another question, it's as well kind of related to the first questions we had. It says, how long after the hearing can I expect an order? Ender, would you like to answer that, please?
Yes, that is dependent again on the board and the backlog. Not only that, but the specific adjudicator that's heard your matter. It depends on their backlog as well and how long they're taking to write that order. I do know during the processing phase and through the pandemic, we were being advised that orders would be generated within 30 days after the hearing date. We have unfortunately again seen applicants wait 60, 90 days. We do advise that if you're past that 30-day mark, that you do reach out to the landlord and tenant board and inquire about the status of your order at that point.
Thank you, Ender. Another question says, if the tenant does not keep up with the payment plan and I have to file the L4 application, do I also have to pay another filing fee? Natalia, would you like to answer that, please?
Yes, thank you. Absolutely. Unfortunately, you do have to pay another application filing fee because it is another application. For the L4 or the L3?
Sorry,
Sorry,
It's L4. Sorry,
Oh,
the
my
L4.
apologies. My apologies. I thought you said L3. No, there is no filing fee for the L4. Good news. My apologies.
Yeah, so that would be a subsequent application based on one of the type of orders that we talk about during the presentation, which usually has section 78. Okay. So another question says, what if I get an order for arrears and I have to collect? I think this is more pertaining to the garnishment process. Maybe Ender, would you like to answer that, please?
Yes, so then yes, this is more likely pertaining to the garnishment process. So the LTB would be, the one to go to at up to the point where you receive an order for arrears. After that point, you will definitely have to use a different arena. So it would be via the small claims court. And so you will have to take that order that you received from the landlord and tenant board to the small claims court to start the garnishment process. If you're not familiar with the process, obviously you can use a representative. There's also the option to contact a collection agency to go about it that way and try to collect on arrears that way. Bear in mind, obviously, that in order to collect on an order for arrears, that the party that you're looking to collect from does need to be meaningfully employed in order for you to be able to obviously collect from that person.
Thank you so much, Ender. Another landlord sent in the following question. What if I apply to the landlord and tenant board for eviction, but the order I received from the landlord and tenant board does not have an eviction date? Natalia, would you like to answer that, please?
Yes. So in a case like this, it may be that eviction wasn't rendered. So in essence, it's also important to note that the order may not directly state that there is an eviction, quote unquote, with that word. It may say in order to terminate tenancy or the tenancy is terminated. So just a side note to be mindful of the wording, because if you're, I've had landlords skim the order and see that they don't see the word eviction. They think that the tenancy is continuing, but that's not the case. You need to ensure that it doesn't state that the tenancy is terminated. So if you reviewed the order, you don't see that type of wording, it does ultimately mean that the tenancy is not terminated. And there could be a few reasons for this. One of them could be that it was, you've entered into a payment plan and both parties have agreed to continue the tenancy and that the tenant, pays a certain amount a month to catch up on the arrears. Another one could potentially be that the landlord didn't ask for a termination of tenancy. As we mentioned in our presentation, that the adjudicators have discretion of how they want to put forward their hearings. So sometimes an adjudicator, and I've seen this happen where they say, and what are you asking for today? Just point blank to the landlord. So it is important that if the landlord is seeking a termination of tenancy, then they state that on record so that the adjudicator could write it down, because just relying on the notice that you serve, so for example, an N4 notice, that wouldn't be enough for the adjudicator to infer that you would like a termination of tenancy as well. Depending on the adjudicator. I have also seen orders with termination of tenancies where the landlord didn't explicitly stated that in the hearing, it was alluded. But just better be err on the side of caution in this situation, and just if you're looking for a termination of tenancy, to state that on record. So the adjudicator will make note to that.
Yes, just to add to that as well, Natalia, in some situations, even though a party has applied for eviction, the board may find that enough evidence wasn't provided to support that request and decide not to order termination of tenancy. So again, it's good to be, thorough with what your request is and how to present your evidence.
Thank you so much. Okay, so another client is asking, so the tenant has been sending evidence by email. The client has received over 90 emails. The adjudicator tell the landlord that they had consented to to receive evidence by email, but the client would like to know how to turn off the portal in order to not to allow consent by to get evidence by email.
So, okay, it would have been nice to get some more clarification here because so I'm understanding that prior agreement was there where one party agreed to accept evidence via the portal, but they're saying that it's too much and now they're looking to renege or remove that agreement. Once the agreement though is reached and you have signed off on giving that person the authority to do that, I have never experienced anything, and correct me if I'm wrong, Natalia, where you can actually renege on that or change your mind mid process. Once you've given that once you've agreed to that and given that permission, then that's the way that it's expected to be presented. And so I'm not, feel free to jump in, Natalia, but I'm not familiar with any way that you can change, midstream and decide. Again, you can nicely ask, maybe just compile all your evidence together and submit the one submission, but I wouldn't see a way for you to turn it off. And again, even if there was a way to turn it off, that may impact you negatively, because again, you turning it off does not mean that the tenant is not sending that way, and you may just miss important evidence at that point.
Yes, absolutely, Andrew. I agree. I haven't seen a case where you're able to go back and change that. And we do understand that it is frustrating to have 90 separate emails of evidence. However, ultimately, once it's consented, it's hard to go back. And like Andrew said, and also another thing is that evidence is time sensitive. So once again, we don't know the timelines of this specific matter, but if, for example, the board says, evidence has to be in 7 days before the hearing, and it's the 8th day before the hearing, well, then unfortunately you can't change the method of serving the evidence, because it will then compromise and that timeline that parties have to adhere to ensure their evidence is heard. So just compile it all in one folder, maybe an email, and or kindly, like Andrew said, ask if they can just compile all the evidence into one, but it may go and interfere with the timeline. So may be difficult to do.
Okay, thank you so much. Just so everyone knows, there is a form on the Landlord and Tenant Board website called Consent to Disclosure through Tribunals Ontario portal, which is a form that allows both the landlord and tenant to disclose documents, evidence, submissions related to the Landlord and Tenant Board matter, and they're able to share those through the Tribunals Ontario portal. As well, the form says that if one of the parties decides not to keep, sharing documents through the Tribunals Ontario portal, they need to tell the other person in writing that they no longer want to share documents and submissions through the portal. So yeah, it's important for clients to know that this form is available on the Landlord and Tenant Board website. Okay, so we're continuing with the questions. Somebody else is asking, what if I don't file the eviction on the date specified by the Landlord and Tenant Board in the order? Natalia, Ender.
Sure, I'll take, I forgot who answered the last one, but I'll take this one. So the LTV order is valid for 6 months. So you can file for the enforcement of that order within that time. However, as best practice, it is encouraged to file the order as soon as possible, just because it's something that, you can get off your plate, and you follow through what the Landlord and Tenant Board had told you to do. So if they say, on the 25th, you can go to the sheriff's office, pay the filing fee, fill out the form, and file that LTV order, because we all know that we're very busy and time flies, and you don't want to forget about it, and then you need to enforce it, and then you can't. And we all know how daunting having to start this entire process over may be. So once you get that order and it's fresh in your mind, just go ahead and file it, and you'll have that peace of mind that it's already with the sheriff's office.
Thank you so much, Natalia. Just as a reminder, any questions that are specific to a case, we're not able to answer those today because we're not providing legal advice. So if you would like to obtain legal advice, please visit our website to find out how to contact us by phone or in person, or send in your question by email. Okay, so another landlord is asking,
Can an order be issued in the mediation room, or do the parties have to go back in front of the adjudicator? Ender, would you like to answer that, please?
Yes, definitely. So if you do end up in a mediation room and you did have a meeting of minds and you have an agreement in place, what you get from the mediation room or the mediator would be a mediated agreement, which means that in this type of order, you usually have to go back to the landlord and tenant board with some regard to get an official order if something in that mediated agreement did not stand up. So if you're requiring a more official document in way of an order, what you would do at the end of that mediation, once there's an agreement, you would ask the mediator to be able to go back before the adjudicator in the hearing room, and there you would advise the adjudicator that you have reached an agreement, and you're, instead of going with a mediated agreement, asking the board to issue an order with the same terms, but again with an order instead of a mediated agreement. So yes, if you do reach an agreement in mediation and wish to have that in place of an order in place of a mediated agreement, you will have to go back to the hearing room in front of the adjudicator to get that done.
Thank you so much, Ender. Another landlord is asking, what happens if I log on late to the hearing? Natalia, would you like to answer that, please?
Yes. So a lot of factors can contribute into what can happen, but some of the scenarios that we've seen happen. So unfortunately, the worst case scenario is that the landlord may miss their hearing, and you definitely want to avoid that because, well, first off, if you're the applicant, so you've served a notice and you filed the application against the tenant, your application may be dismissed if the tenant shows up and you are not there. So then you would have to start the process over again. Also, if roles are flipped and for example, the tenant is the applicant, they filed against the landlord, making the landlord the respondent in the matter. If the tenant is present and the landlord is not, in this case, they're responding to the application, and the tenant presents compelling evidence and they're able to present their matter in front of the adjudicator that persuades the adjudicator of their application and the allegations, the adjudicator may issue an order against the landlord without them being there. And an order like this can contain either amount that's owing, that needs to be paid to the tenant, right? So in this case, maybe not an ideal situation, especially if you had good evidence to refute what the tenant was saying. So you definitely don't want to log in late to the hearing. You want to make sure you're on time, and that's why we, as mentioned in our presentation, it's encouraged to sign in about 15 minutes early. But another thing that may happen is you may log in late, and depending on the volume of matters that are heard that day, you can log in, advise the moderator that you're present for this rental unit, who you are, and you may be put in the queue because your matter wasn't called yet. So yes, that is, a lucky situation, but we don't encourage anybody to hope for the best and log in an hour late, because if it's a quick hearing, it's an adjudicator that speeds through the matters, you may miss it. So just do your best to be on time. If you are running late, if something happened, there's an emergency, try to call somebody to at least call in and appear on your behalf as an agent, and to just say that you're there and to hold the matter down so your matter won't be called without you there, because you definitely don't want to get an order issue against you if you're not present and then have to go backwards to reopen the matter, and it's a big headache. So yeah, just try to get there on time.
Just to add as well, if unfortunately this does happen and you show up and your matter has already been called and been dealt with, you will have to go the process of filing a request to review after you receive the order. Again, it would be at the board's discretion whether that request to review or a new hearing would be granted based on your reason to request that review. But that would be the best way if, again, everything's happened and you're notified that your matter was dealt with after when you appear. So yeah, we request a review.
Thank you so much, Ender and Natalia. So yeah, another landlord is asking, what is one of the biggest issues you've seen or encountered during a hearing? Maybe both can share some of your experiences, please.
Okay, so I've seen quite a few issues that had happened at the board. Ultimately, there's the fatal error, which you see very often, and I've seen fatal errors that are, very black and white, that the termination date is completely off or the amount is completely off. But I've also seen an issue where one like the address, the number of the units. So for example, instead of saying 15, it's at 5, and that's enough for it to get dismissed. So definitely I've seen a lot of fatal errors at the board. And another major issue I think I've seen is the witnesses. I've watched hearings while I was waiting to present my matter where the landlord had witnesses to assist in speaking in his matter, and he was going through and direct examining his witness, and the witness actually was saying things and responding in a way that was supporting the opposing side. So this did not go over well because ultimately the testimony of the witness has weight in the matter, and the adjudicator hears what the witness says and they take into consideration what the witness says, and that ultimately discredited the landlord. So in a case like that, I think it's just, a pointer is to make sure that whoever you're calling as a witness will be of assistance to your case and not the opposite, because you don't want to have a witness speaking against you.
Yeah, I think this ties into one of the biggest issues I've seen as well, is where the party is not prepared, fully prepared, because again, being prepared, a part of that would be making sure that your witness's evidence lines up in your favor or showing what you need to show. So that's one of the biggest pitfalls that I've seen, is a party being unfamiliar with the evidence, or even unprepared, or unfamiliar with the actual landlord and tenant board process and what to expect from the process, and even what remedies are available for that specific type of application, and what to ask for, or again, what's available to them as a remedy, right? So yeah, again, a lot of parties that I see, sometimes I'm sitting there silently going, just ask for this, or you wish you can say something, because again, it's just as simple as you requesting something, and if you are more prepared, then you may have been able to know that this particular remedy was available. So yeah.
Thank you so much, Andrew. So yeah, that's one of the things that landlords, when they call the office, they usually ask if they can send somebody else to speak on their behalf of the landlord tenant board hearing. And we emphasize that whoever they send needs to be prepared to speak on all the matters, needs to be well prepared to talk and defend the case. If it's somebody that doesn't know the facts, then unfortunately the case will not be successful. So that's very important. Natalia?
Oh, and I was just going to add to that, Diana, as well, is that, when you're going in front of the adjudicator, you want to go through your application, because when you're filing your application, it asks what remedies you would like. So you want to make sure that when the adjudicator is asking you what would you like to happen, or what would you like ordered, or what are you here for, basically, you want to make sure you go through all of the remedies, whether it's compensation, whether it's a termination of tenancy, and that you state them on record to the adjudicator. Because, and like Ender briefly touched on before, when we addressed the question of what happens if you miss your hearing and there's an order against you. If you forget to ask for a remedy and you get that order, you can't just ask them to amend. There is a form that you can request to amend an order, and that's not for these types of amendments. So you can't just go back and say, oh, I forgot to mention that this is what I would like. You would have to restart the process. The request to amend an order, if there's a clerical error on the order that you can prove based on the application and the notice, we can have that discussion about that form. But if it's because you forgot to ask for a termination of tenancy, you may have some challenges there.
Yeah, it's important to note that it's not because it's on the application, it doesn't mean that the adjudicator is going to consider that. You still have to put it on record as this is what I'm asking for. Don't just leave it up to the application, because then again, it may not be mentioned, and then you're probably not getting what you're seeking.
Thank you so much to Natalia and Ender for all your answers. And we really want to thank everyone for attending our webinar and sharing your questions with us. As a friendly reminder, please fill out our survey. It will help us improve our future presentations. If you came in late or someone you know was not able to attend our webinar today, we will be sending the recording link so you can review it or share it later on. It will be available through our website as well. So even if you don't receive the email link, you can just visit our website. It will be available on the website as well. And we look forward to seeing you at our future Landlord Lunch and Learn presentations. Thank you so much, everyone.
Thank you.
Thank you, everyone.